he did. Just to remind you that she is a professor emeritus from Westchester University and has spent a good deal of time studying, and although she went to law school for a year, she decided, much to my surprise, that not to be a lawyer, but she couldn't get away from it. So this is the second in 8 talks on justice in early America, and this one is going to focus on military court-martials during the American Revolution. Linda, take it away.
Hi, everybody.
Hi.
Okay, so we'll continue with our discourse on justice. And in this case, we're going to look at the first federal judicial system. The military courts during the Revolution constitute the first opportunity that this new nation has had to have its own courts run in its own way. Surprisingly, they chose the British Articles of War as the controlling document for the courts. Go figure. In any case, be patient with this speech. It's different from the last one, but it will focus on one particular case, which is helpful. But it won't be all over the place. There'll be some unfamiliar terms, which I'll patiently explain. This case actually covers 8 trials, but we're not going to discuss them all. I'm going to show you why it's important to know that there are 8. There's a big cast of characters, and let me go start the whole thing by just showing you what a military court-martial would have looked like. If we can have slide 1. And it's a mess. This is a caricature from 1832. And it's titled Much Ado About Nothing, a court-martial. This court-martial is exactly the kind that you would have had initially. That is in our period. Ours will be 1783. The war will actually end slightly after the court-martial, but since the series starts in 1776, we are going to pass through most of the revolution. Yeah, 1776. Here you have, going from your right to your left, I'm sorry, your left to your right, your left. Oh, I have to hold it down. Here we have a witness testifying. He refers to his profession as a self-styled gentleman. Well, it should suggest something to you. As you can see across the bench, there's a pile of giant-sized hats for the outsized egos of the presiding board of officers over the court-martial. Here is a sword which in English reads, but it's in Latin, for love of country. Over here we have 2 blacks discussing who are these people, and who in particular is this fat gentleman over here with a long list of witnesses, and in his back pocket a pamphlet that says the trial of Colonel Pluckett, and that is Colonel Pluckett. Hard to see, I'm sorry, his dimensions. Here's a character who is snoozing and basically says, just stuff him in a cannon and shoot him out. We'll pick up the pieces on the other end. Here's a gentleman with a cold who says, if my nose doesn't blow, I'm going to court-martial it. It gives you an idea of the comic status of court-martials. This style of court-martial lasts until World War I, and you'll see that there are plenty of problems with the way in which the law is handled here. But the Articles of War aren't really changed until World War II. This is a militia trial because we have this issue in the Constitution, Article 1, Section 8, that says that Congress shall not appropriate money for a standing army that lasts more than 2 years. That is the appropriation. Doesn't mean they can't keep upping the appropriation. But the point was that they suffered so dearly under the standing army and the British Empire that they were determined that they would disallow one for this new experiment in democracy in the United States. So basically we relied on citizen militias. And citizen militias became a problem because citizens felt that they should call the shots in the army, and that you couldn't, a military commission had no right to challenge its rights to be armed, sounds familiar, by virtue of court-martials. When I come across that in my notes, I'll explain in a little more detail. So keep in mind that this is an early part of American history. Everything is in flux. So this nation is inventing itself. Courts are reinventing themselves. They're trying to find their identity, mix match out of some inherited judicial practices, out of some invented ones. So you won't get a linear sense of a developing judicial system over the early republic. So throughout our series of 7 trials, you're going to pretty much ride a roller coaster. But I'll try and create a sense of some of the principles or the themes or the structures that finally emerge towards the end, because by the beginning of the 19th century, we will begin to have what you're more familiar with, which is the adversarial style of lawyer-based jury trials. I call it lawyer-based for a reason. You'll see why as we go along. But we're going to be looking at state, federal, and county courts, different types of cases, civil, criminal, private prosecution, and state prosecution. The state did not prosecute criminal cases until late in the early republic, which now the early republic goes up to 1830. But up till the very beginning, like 1808 of that century, the state still wasn't prosecuting criminal cases except in exceptional circumstances. So people became their own prosecutors. They brought the evidence. They brought the charges. George Washington, in one of these cases that we'll reference, will actually prosecute his second in command in the Continental Army, General Lee. And Lee will be suspended for a year from service in the middle of the revolution, mind you, because he did not embody the appropriate military characteristics, nor was he truly an officer and a gentleman. And the officer and gentleman cachet is going to speak to the fact that the second leg of military jurisprudence is really based on the honor system. And so the honor code had validity. In fact, it was embedded in the Articles of War. And it had an equal validity to the Articles of War in terms of its legal criticality. And we'll talk about that a little bit as well. Okay, we can go to the second slide, which is going to give you an idea of some of the characters here. We're going to meet all these people. There are a lot of people. But if you look at the first 3, these are very prominent figures in the rebellion. You may be less familiar with Baron Friedrich von Steuben, but for him, we would not have won the revolution. He came over as a Prussian soldier, and he brought state-of-the-art thinking about military warfare. And between him and George Washington, they carried it off. Those are the 2 that get the greatest credit for having won the revolution. The next 2 characters, Hazen and Reed, are the 2 whose feud sponsors this whole cascading series of 8 court-martials and courts of inquiry. And their feud was essentially based on the fact that neither wanted to be humiliated, because how could they face other gentlemen if they were not vindicated by a court-martial? Below them, General Henry Knox founded West Point in 1980. It didn't last very long, only a couple of years, and they decommissioned it at the end of the Revolution. But he was luckier than George Washington was. George Washington sent several proposals with regard to reforming the military and establishing the Continental Army. They were all rejected by the Continental Congress. So Knox felt himself particularly privileged. The two next, Putnam and Gayton, are going to be the most important presiding judges of the important courts-martial that deal with this feud between Hazen and Reed. And now we come to General Horatio Gates. He's a very interesting character. Some of you may be familiar with the fact that he and Brigadier General Thomas Conway led a group of officers who conspired to replace George Washington as the commander-in-chief of the Continental Army. Interestingly, he apologizes and is forgiven, and winds up being chosen by Washington to head a court of inquiry that will investigate the courts-martial, which was a favored project of Washington's. That is, he believed, as you are perhaps familiar, very much in the importance of the military. He was a military man most of his adult life. And for him to select Horatio Gates was a sign of a great forgiveness, but also a need to use a man of such talents. Below them are some of the next three, are three of the, again, presiding officers over some of the trials. And then we're followed by the judge advocate generals, who were the prosecuting authorities in court-martials. And they replaced each other serially. So it starts with Tudor, goes to Lawrence, Edwards, and Deputy Mr. Strong comes in between in the transition period. So these trials pretty much exhaust some of the real leaders, makers, breakers, and shakers of the Revolutionary Army. Which takes us to the next slide, which I'm going to leave up. You may or may not be able to follow it. So I have some handouts, and if you want to share them, perhaps. So if every other person takes one, maybe you'll get some value from it. These are the, in the first set, to the left. If you'd like to pull the lights down so they can see that more clearly till I finish talking about it, then I'll, yeah, my thing won't work otherwise. You can take the light down on me. Okay. Does that work better? Okay. No, we're going to go back. After I introduce this, we're going to go back to be talking, and we'll put the light back on. So these first three are precursors to the feud, and then the feud starts here, and it goes through for 5 more trials. So if you follow Hazen, now Hazen's going to show up in the defendant's column. Let's see. Sorry, I'm in the play. Let's see, wait a minute. I'm going to make sure I have the same one. Yeah, Hazen shows up in the defendant column here. No, that's Tudor. Okay, helps if I take my glasses off. All right, so he shows up here. Hazen shows up here. He's defending, right? Benedict Arnold prosecutes him. Von Steuben prosecutes him. And he turns around and prosecutes von Steuben on exactly the same charges that von Steuben took him up on. And here we have 2 advocate generals, one after the other, dealing with Hazen. Here's the presiding judge for that panel. And we find Hazen acquitted. We find him acquitted. Well, here's the problem. Washington needed officers in the field. And he was very reluctant to take them offline. So that's going to be one of the first prejudicial factors in how these judges are going to conduct these court-martials. All right, so here he turns around and prosecutes von Steuben, and the verdict, it was resolved by agreement. Neither man could afford to lose too much honor over this, so it took 8 days for them to reach some kind of accommodation. Now we get to the feud, and there's Major Reed on behalf of the regiment accusing his superior of corruption under this Advocate General and under this judge, he's acquitted. Surprise, surprise. But without honor. So that means he's half acquitted, right? Because the code of honor is so important in court-martials. So what does Hazen do? Walk away with his victory in his pocket? Or his half a victory in his pocket? No, he turns around and he tries to prosecute, that is, bring Reed to a court-martial under a new Advocate General, who then will stay in play until the end of the war. And this is the important Grayton trial, and this will be the important Putnam trial. Now notice that there are 2 years between them, right? And guess what's going to happen 2 years later? Hazen's going to prosecute him again, right? And then there's going to be a court of inquiry down here, number 5, where this trial and that trial are going to be themselves tried by a court of inquiry, right? Under another panel. You see all these panels? Every time you pull off a panel like that, you got to pull 7 officers off the line. All right? So I'll talk about that in a second. So he's Hazen's first trial of Reed to get back at him. Minor charge, guilty on 1 charge, only deserves a reprimand. He is unhappy about that result, so when he takes him up again and prosecutes him a second time, he rearrests him almost immediately after he's released. He tries him, and again, he's acquitted on all but a minor charge, which was so trifling that they decided not to censure him. All right, and then the 2 courts of inquiry will end the series. We'll focus on this one because this is where the court-martial system will actually be tried, because of all of these trials involving Hazen and all the charges and countercharges, many of which went against the board of judges, the board of officers who presided over this, and the Judge Advocate General. They were all attacked by Hazen and Reed through these trials. So George Washington has to pull more officers off the line in order to inquire into the fairness and equal treatment of the court-martial system as a whole. So these did a great deal of damage to court-martials as a system of military justice. You can put the lights back up if you don't mind. Okay. Is that too much light? You can put it down a little. Thank you. Down, down. No? That's good. That's a good compromise. Okay. All right, so what are we going to look at? We're going to look at what is military law, what's the court-martial system, what about feuds and duels, and we'll see how much of it we get through. I'll try and sample most of it. So military law was designed to preserve discipline and order. It had virtually nothing to do with truth or justice. That's a pretty harsh indictment, but I think it's demonstrated through these cases. And it's also demonstrated through treatises by Judge Advocate Generals themselves, both British and American, who had to live and fight under the Articles of War. Since we adopted the British Articles of War, in toto, the experience of the British, and I'll call them from now on JAGs, right? Judge Advocate Generals, so we have fewer syllables. So British JAGs and American give us a lot of treatises on military law, and in all of them, they are very harsh about the system of military justice that they have to operate under the AOW, Articles of War, since they were in common. And we'll talk about that in a second. So, William Blackstone, an 18th century English common law commentator, he's the most important judicial influence in Anglo-American jurisprudence. The Americans adopted his work wholesale when it became available in American printing in about 1760s or 70s. He referred to the law of war as built not on settled principles, entirely arbitrary in its decisions, indulged rather than allowed as law. He considered that soldiers that were prosecuted under its court-martial system were reduced to a miserable slavery. Its rules are neither concealed, they are either concealed or precarious, vague and uncertain. And the sole justification he claimed for a military system of law was the harsh requirements of war. So that's the starting point. The JAGs are condemning the system for being uncertain, unpredictable, unfair, unequal. And Blackstone, the premier commentator of Anglo-American jurisprudence, is also making the same case. So on what was the law of war founded in the American Revolution as far as the American Continental Army was concerned? Well, first, they used a 17th century work, actually 1604, so it's pretty much the very beginning of that century. Hugo Grotius's Of War and Peace, and it proved extremely influential in early America. Basically, it was a work on the rights of aggression, the rights of killing the enemy, the rights of spoiling, rape, the right to confiscate property, rights over captives and over the vanquished. And there are some minimal sections on moderation and discourse and reason. I guess you get the balance. It's not going to be influential in those areas. Soldiers also trained under manuals, and the most important manual was the Blue Book, which was written by von Steuben, who actually wrote it, came from Prussia and wrote it for the American Army. But as he conducted his military drills, he conducted them in French and German, so there had to be somebody next to him translating as he was barking out his commands. As I said, the British Articles of War were the controlling document for the courts. They broke down like this. There was a sovereign identified, the Continental Congress. There was prosecution on behalf of the sovereign. That's the JAG, Judge Advocate General. There's a court-martial board to deliver the verdict or sentence. You notice I didn't say anything about a jury, right? So the court-martial board is going to be judge and jury. By the way, and executioner, because they deliver the sentence. And then they have the commander-in-chief or the Continental Congress, which approves the verdict. So that's the system, the structure of the system. In the AOW, the Articles of War, there's an infamous last article, which is called the Devil's Article. And it gives blanket discretion for all non-capital crimes that prejudice good order and military discipline. What does that tell you? That everything before that article, as long as you didn't kill somebody, didn't count for anything. And everything was left to the discretion of the board of officers. So it kind of undermines itself as a legal document. These trials were summary trials. They were essentially without full proceedings, almost like ex parte justice, where you have nobody to represent you. It's a lawyer-free system. The accused speaks. That's another word they use for this kind of trial. Another word they use is the altercation trial, which means that largely it is an altercation. You saw the image that I showed you of the court-martial, Much Ado About Nothing. It's basically that. People stand up, they holler, they out of turn, there's very little order, there are no rules of evidence, and basically the courts did not embrace principles of equality, due process, and justice. So this is a poor start. It's a very shaky start for the first federal court system. The death sentence required a 2/3 vote, so maybe there was a little leeway there. The accused, however, has no one to represent him. He has a right to introduce evidence. He has no right to cross-examine prosecution witnesses. he carries the burden of proof of his own innocence. There is no presumption of innocence, and there's no provision for reasonable doubt, either according to one's conscience or moral certainty, which were the terms that were used to define reasonable doubt in the period. And he cannot argue his case to the jury. So these were very speedy trials because you've eliminated a lot of what it would take to give real consideration to a case. In these trials as well, several things were discouraged. Now, there's a lot of borrowing from military law, by military law, from the civil court system, because remember, military law is a new invention for us, in spite of the fact that we're carrying over a lot of inherited material like the AOWs. So there are practices, uses and practices that are common to military cases that are carried over, but they're not documented. Like common law in England is a series of judge-made decisions that are embedded in the law and that are retained as case law, and relied upon as precedents. Well, here, the military court system rejects the idea of precedents. Their claim is that every case is uniquely and independently based on the particulars of that situation. So they don't allow common law cases from the civil side to be brought in as precedents. They only allow military custom to be brought in, and even that custom, which could become precedent, right, is discouraged. So they discourage legal counsel, they discourage legal precedent, they definitely disfavor any introduction of legal authority or legal citations, you know, from statutes, from English law, from common law. And they're based largely on what's called lex non scripta, which are just usages, you know, unwritten law that's known or familiar to the board. The unfortunate thing here is that the board members have no knowledge of the law. They're officers. The Judge Advocate General is chosen, but not because he's a lawyer. One or two of them were lawyers, but they weren't very successful lawyers, which was why they joined the Army. So we weren't going to get much law from them. So we find undefined penalties, inexperienced boards, JAGs who basically don't know much law themselves. And then we'll turn this whole thing over to this kind of a system. The Judge Advocate General will advise the board on the law, not knowing much himself. He will prosecute this case for the state. He will advise and represent the accused, and he will in fact be the only source of information because you're disallowing references to precedents and statutes and other forms of law. So he is caught in what's called the Proteus posture, which is taken from the myth of Proteus, who is a mythical figure, classical figure, who constantly changes his shape, right? Well, he's going to have to prosecute for the state, but not prosecute so harshly that he can't honor his responsibility to the accused, right? Because the accused is not allowed a lawyer. And he must advise the board, but he may not recommend to the board. The board is to decide. So he's caught in between these three places, and when it goes wrong, it's his fault. So he is very shy about coming on too strong or being too aggressive in defending the accused, because he will himself find himself, as Edwards does, in a court of inquiry, where he will himself need protection for his role in conducting a trial. So what about lawyers? Lawyers were discouraged. They were not forbidden, right? So there was a case in 1809 where a court-martial run by Captain Wilson, of Captain Wilson, but was presided over by General James Wilkinson, famously referred to the use of lawyers as a temptation to tease, perplex, and embarrass by legal subtleties. I know there are lawyers here, so this is giving me a lot of pleasure. They were to prepare the defense for their client in writing, but they are not to open their mouth in court. And they were to submit whatever questions they had to the board, and the board would take it from there. And the great fear was that leaving court-martials open to the legal bar would lead officers on the panel and the JAG himself to the terrifying prospect of directing, quote, their attention from the military service and art of war to the study of law. So this was a great negative. Well, we have military men who are not versed in legal subtleties, and if you do have counsel, that counsel knows very little about military practices and procedures, and so we will wind up with court-martials that will deal largely with violations of military discipline rather than questions of law. And an interesting statistic for your attention is that there are very few studies, by the way, of courts-martial, but a good study that was taking place at Valley Forge during the years that our Army lived there shows that 60% of Washington's general orders that were disseminated in the camp involved courts-martial of the officers. 10% of all officers in the year of 1778 were court-martialed. Of 605 cases in a 21-month period, 405 officers, or 3/4 of them, were convicted. And as I said, George Washington himself prosecuted his own second-in-command. And in that case, in order to demonstrate the real price you pay when you hold a court-martial. Remember, George Washington does not want to pull his men off the line. He wants them fighting. General Lee's case involved calling 37 witnesses. It was held over 27 sessions in a 38-day period in 5 different locations. The Army keeps moving, right? And in each case, each one of those sessions, 27 sessions, you have to pull a panel of 13 officers off the line out of the field to act as a trial board. Well, he was found guilty on all 3 charges, but I don't know how they remembered from one day to the next what they were doing. So holding a court-martial, it was a bit of a push to get a court-martial going because there was an incentive not to hold court-martials for this very reason. Okay, so we're now finally at the court-martials that we wanted to talk about, and it's the feud between Hazen and Reed. And it's going to expose the faults of the system, and let's see if it exposes anything positive. But Reed comes forward because, in this case, he claims that recruitment bonuses, no, that's not going to work there. He charged Hazen with embezzling regimental money, padding the payroll with absentee soldiers and non-commissioned officers, which means where did that money go if they were not on the roll when they were invented soldiers? And the fact that he had hired Hazen, the brigadier general who was his commanding officer, had hired his own nephew as paymaster, and his paymaster nephew, Captain White, was covering up his conduct. So those are the charges against him. And Reed presents himself as a whistleblower, and that he's representing his regiment, who feel that they have been defrauded by Hazen. The court itself, the board of officers, and the commander-in-chief, Washington, they, in their communications, refer to Reed as being persecuted by Hazen. So that's a second way of thinking about this. There were 24 officers who, during the course of Reed's prosecution of his commanding officer, were themselves defamed by Reed. They felt that their honor had been attacked, and they demanded their own trial, which will show up on the list. The second trial where Hazen, under the Grayton Court, I think, when he goes to trial the second time against Reed, all 24 officers under his command will join him. And Reed then claims that he's being retaliated by those officers because of his attack on their commanding officer. So everybody has their own point of view. They all have their own positions here. Well, as I said, in the end, for all of this, nobody really gets court-martialed in a way that they are penalized in any significant way. Okay, so let's talk then about the actual feud. And see how much of this I can skip. All right. In the first case where Reed, number one up on the board, where Reed prosecutes Hazen, he will not specify the charges. And Hazen writes to George Washington. You're going to find a lot of letters back and forth between Hazen and Reed and George Washington, and then back from George Washington. It seems that they couldn't let him off the hook, you know. He was so intent on preserving the court-martial system that he allowed himself to get sucked into this feud, so that anytime there was a verdict that was against a particular party, that party would then appeal to Washington, or before a court-martial, they will write to him and present their case in what's called a memorial directly to Washington, hoping that he'll interfere on their behalf. So Hazen, who's now being accused by Reed in the first feud trial, writes to Washington and says that if you're not going to particularize the charges, how do I know how to defend myself? So he doesn't actually defend himself in that trial. He doesn't call a witness. He doesn't, present a case. And he is acquitted, which suggests that Reed didn't have a very good case. Now, why would a problem like not specifying the charges been allowed? Why would that practice be allowed by the board of officers who oversaw the court-martial? Well, that goes back to what I suggested before about the problem with honor and feuds. One reason why you have a legal system in the 18th century is in order that people will not challenge each other to duels and use that informal system under an honor code of replacing a lawful order, right? So courts grew up in order to diffuse the whole idea of feuding. Well, if you specify a charge, you're going to defame somebody, you're going to libel somebody. And that's just likely to bring on feuding as not giving people the option of taking a feud to court. But you take it to court, and then you defame them in court, and then they don't get the verdict they want in court, and then you have the duel and the feuding. So this was a big problem in this period. And so Reed got away without specifying the charges, but then Hazen got away without having to defend himself, and then there was an acquittal. So that's going to be a continuing problem for court-martials. All right, so what happens after he is acquitted? Who's going to write a letter to George Washington? Reed, right? Reed loses the case, so he writes to Washington, and he complains about the court, that the court refused to replace the prosecutor, the JAG, the JAG, that the panel that was chosen was prejudicial to his case, and that he should have been allowed challenges, but the board disallowed challenges against itself. Sounds like a conflict of interest, right? And he wanted the JAG to be replaced, and he was denied that. Washington does nothing. All right, well, Hazen sees this, so Hazen turns around in number 2, the second trial, and he charges Reed immediately after he is himself acquitted. And Reed does something very interesting. He recollects that there was a prior practice, remember, customs and usage within the Army was the only real kind of context in which law could be brought in if it had been done before in another case. Well, Reed had defended himself in the von Steuben trial, which is up there as an August 1780, the second trial down, by reading a defense where he attacked his prosecutor, von Steuben. So Reed decides to adopt that strategy, and he produces a manuscript in this trial where he defends himself against Hayden. And the whole defense is a series of attacks on him and his officers, dishonoring them, figuring he can get away with it because it's inside of a court, right? And the Articles of War, there are 5 articles under the Articles of War in Section 7 that focus on the question of honor and conflict resolution, and they forbid challenges, provoking speeches or gestures, and they reward refusing a challenge, but they also require that members of the boards of the court-martial must behave with calmness and decency, not to provoke feuds and duels. So the board allows the defense, but makes draws the conclusion that the defense, this manuscript that Reed read, can be tried in another trial. Well, that's a window of opportunity for Hazen. So what happens? Hazen's going to try him for that as well. That's going to be another case. It just, it's like wheels within wheels. It's a never-ending thing. So the reading of the defense now becomes the case under, in number 3, if you could see number 3 here, under feuds, the third trial down, which is the Putnam case, right? Where now the 24 officers charge Reed. They charge him along with Hazen, and the 24 officers charge Reed. And in that case, he is, let's see, Putnam. He is not censured, and he is acquitted on all but a minor charge. What's the next step? That's not enough for Hazen. He decides that he needs to have the whole court-martial system now be put on trial. And Washington felt that he had no choice after all of this. He had to stop the feud. So he appoints Horatio Gates and sets up a new board, and he asks to determine whether the JAG's conduct, the judge advocate, was neglectful and partial. And he counseled the board that this is an attack on the military system of justice itself, and it's an indication of the damage that this case has been doing to the military justice system. So this is going to be a high-powered kind of investigation. Again, it's like a grand jury investigation, where the grand jury determines whether or not it ought to indict or bring charges. Well, when in this investigation, the Court of Inquiry against Edwards, which is number 4 under feuds, that's the way Washington had set this up. He wants to know exactly whether the charges against the JAG were true, Hazen's charges now, and if they were true, are they military matters? And the court determines that they are not true, but even if they were true, he still wouldn't be convicted because they're not military matters. So if he was partial, doesn't matter, that's not military. If he's neglectful of his duty, that's not a military question. If he doesn't know the law, these are the charges that were made against the Judge Advocate General. That doesn't matter because it's not a military question. So as you can see, law matters less than questions of war and what it takes to get his officers and his soldiers back online to fight the war. All right. Well, at this point, we have Hazen's he brought counsel into he brought legal counsel in. I mean, we find it was discouraged, but he decided to bring it in. And instead of relying on himself, because he's taking on the whole court-martial system. And so he has the court-martial system trying the court-martial system. So he has the Putnam trial and the Grayton trial, those two, being tried as he's trying Edwards in the Court of Inquiry. And he brings in counsel to do it. And the counsel shows that those two trials contradict each other. Not only was the innocent person not given justice, and not only was the perpetrator not convicted, but the whole system of military justice itself was inconsistent and delivered verdicts in one case that were denied in the other. So he makes the case on 3 points. He says you accepted his defense in the Grayton trial, that is this manuscript that Reed read that was so defaming. But when I turn around in the Putnam trial and I try to make the case that I want to put that defense on trial, you tell me all of a sudden that it's not something that's accepted by the court. It's not something that should be in a military court. And then when I say, but wait, there was a precedent in the first case, so military custom and usage should come into play. And you turn around and say to me, in the second court case, Putnam case, there is no precedent. That does not set a precedent. And then when it comes to the issue of, well, but you said it could be tried again, this defense, as a libel, even if you accept it in the Grayton court, that I could try it in another trial. And they rule that the defense statement is not triable. Well, I think Hazen makes his case. And in fact, it turns out the board did not think so. It was considered not a military offense and the charges were not supported. One might think that this would be the end of it. But we have one more round to go. And in this case, General Washington decides that he must, in order to assert the honor of the Revolution Army, he must allow these officers and this Brigadier General Hazen, who have been left unrequited, to have an investigation, the final court of inquiry, that would investigate whether their honor had been defamed by the defense read by Reed. And he does this because he believes, as he had said in 1981, following the very first trial in the feud section number 1, he said, an inferior officer can never be justifiable in attempts to make his commanding officer suspected and odious to his troops. The general cannot forbear remarking with regret, referring to himself, that it is too common for officers on trial to indulge themselves in a vein of invective and abuse as inconsistent with decency as with the respect they owe themselves and to others. And then he allows this case to go forward. The whole thing is to determine whether or not these men have been so defamed that they can no longer survive in civil society or in a military culture without defending themselves by virtue of a challenge and a duel to finally end this feud. And Hazen himself says that in another letter to Washington, where he says, how, sir, am I to act in my present unfortunate situation? Is there any way by which I may reestablish my injured character? Will my calling Major Reed to an account for his conduct — this is throwing down the gauntlet, right? He's actually warning Washington that he's likely to call him out for a duel in spite of the article in the Articles of War which forbids it. How am I to call him to an account for his conduct and convince him I am not a coward, prove to the regiment and the world that I am not a felon, a thief, or a robber? Should I sacrifice my life in the attempt? Shall I call him out and sacrifice my reputation as a military officer? By this time, he's been promoted to brigadier general, mind you, so he's really laying his cards on the table. Shall I nevertheless have an infamous character as a legacy to my posterity? So Washington has no choice. He allows this case to go forward. And what's the conclusion of this case? He has asked the board to determine whether all measures which are practicable and proper for giving satisfaction to these officers for how they have been defamed, whether they have been pursued, and if so, whether Reed should be brought to trial. They determined that they were defamed, but they also determined that Reed should not go to trial. Nobody ever gets punished on these trials. I mean, I've got 8 trials here where nobody suffered not anything, right? I think this is a real indictment. This case has never been studied. It's never been researched. Right? I wonder why. Well, for one reason, the records in the Department of War burned in 1800. So in order to study this, I had to reconstruct it from letters, from correspondence, from legal documents, and so on. But it is a great case because it really tells you what's going on with court-martials. And as I told you, this system that is used here is the same one that survives until World War I, with minor adjustments. So they do not, Reed should not be brought to trial, they claim, because 6 years have elapsed on one complaint, 2 years have elapsed on another complaint, and Washington gives up. He finally says, I've done everything in my power to give satisfaction to you and can only lament that the measures which have been adopted have failed of the wished for effect. The war is over. So Reed has, run out the clock, basically. 3 years running of this feud in full tilt, and then the whole prehistory of feuding on Hazen's part. And this is the end result of it all. The Treaty of Paris in 1783 ends the war. So what did we learn? And this will be how I shall conclude. Don't worry about your dinners. You're okay. General Knox, who established West Point, and nobody really knows this because that he wrote this report because it was buried somehow. And I think it's a question of what happened to the records when the War Department burned in 1800. But I resurrected it. I discovered it in manuscript in the Library of Congress. It turns out that off of this case, he wrote a document called Thoughts on Court-Martials and the Duty of the Judge Advocate, which could have been used because Washington commissioned it when he allowed the 2 courts of inquiry. He said, there shall be a report from this to reform the court-martial system. And it was submitted within a week and a half of the general orders that ordered the Court of Inquiry. But he drops the ball. Basically, he endorses the rationale that Blackstone had used. If you remember Blackstone, he said that the courts martial were not law at all. They were just another form of war. They were uncertain. They were unpredictable. Well, he endorses the rationale that Blackstone had found concerning. He says, yes, the law of war can be arbitrary. Yes, it should be particular to one case and based on the discretion of the board. In other words, you can't bring in legal citations and precedents and so on. And moreover, you don't need experienced lawyers. And it is sufficient if a court-martial is unclear or uncertain rather than predictable or based in precedent. And then he did something else, one other thing that was problematic. He reinforced the idea of an honor code as being the basis for military law. And he said it's the foundation of an officer's conduct and a bulwark of the military system of justice. Honor underlays their oath and will ensure fairness and equal treatment. Well, you could see how fair all the treatment was if nobody ever gets convicted. Interesting, and my final comments here, Knox's report never addresses the fact that the Judge Advocate General has three roles. That's unconscionable. He could be prosecutor, defender, and advisor to the board, right? So he, and with absent a jury, he's in a pretty nice position if you want to have authority, but pretty lousy position if you want to have a fair and equal system of justice. He not only reinforces that role, but he gives it an elevated authority, giving him the critical chore of pulling the whole together into a more effective operating system. That's his solution for what we've just looked at. So, finally, my last conclusion would be, for your consideration, if Washington's goals were to keep military officers in the field and preserve the honor of the Continental Army, they would, in fact, be an insurmountable obstacle to a fair and just outcome in courts-martial as a systemic problem. So if Blackstone wanted to point out the incongruity of law in war, he needed to look no further than the Continental Army and its military justice system. Think of that word, military justice. If anything is any more oxymoronic than that, I can't imagine. As a court of war, in a court of law in a time of war, it was barely adequate, and it really had nothing to do with justice.
Right.
I leave it with you. Okay, the next time, if you choose to meet with me again, we have to change, correct? Richard?
Yes, it'll be July 5th instead of July 11th.
You have questions? I left you 3 minutes. What else is new?
Linda, I had two questions. One, you expressed some surprise that the Washington appropriated, or the folks involved here appropriated the Articles of War from Britain. What else was available?
Exactly. And they were familiar with the Articles of War because Americans had fought the Indian Wars using the AOW from the Brits. And they had fought the French and Indian War on the side of the British using the AOW. So yes, exactly right.
My understanding is that it's problematic when an officer is in a position of authority over an officer of a higher rank. As would be in these cases, you have a colonel who is the judge in a case where brigadier general is, or a major at least,
right,
is involved.
And that ain't half of it. Wait till you hear that Colonel Grayton sat on the Board of Inquiry, which was appealing his conduct in the prior trial where he was presiding judge. And that happens 2 more times. It happens with von Steuben, and it happens with Major Scott, who are also on the list. These guys are nothing if not, as the Greeks say. Yeah, sure. Okay.
Anyone else?
Thanks, guys.
Thank you.